retransferring the title in the occasional case, which is the most that the Constitutional Court is prepared to contemplate, does not meet the standards of international law or of the Convention, because it fails to recognise the fact of continuing ownership and its legal consequences. So the TRNC registers of title have not been amended, and Article 159 continues to be relied upon in practice by the IPC, as you've seen from Ms. Meliagrou's application and its detailed account of hearings in 2007 and 2008, the IPC relying on Article 159 as its basis for refusing restitution. So the continuing violations which constitute the systemic defect have not been halted. For that reason alone, the systemic defect identified in Xenidis Arestis has not been cured. I would remind you of the paragraphs from the fourth interstate case, Cyprus against Turkey, that we cited at paragraph 25 of our memorial. The Grand Chamber said on that occasion that where the TRNC authorities had an official policy of refusing to allow displaced persons to return to their homes, and where Article 159 remained part of the Constitution, there was no convention requirement to exhaust domestic remedies in the TRNC. And the same is true today. Well, so much for bringing the continuing violation to an end. The other thing that is required to cure the systemic defect is a remedy that ensures genuinely effective redress. We emphasise three elements that are required if such a remedy is to be effective. The first of those is restitution of the applicant's peaceful enjoyment of their property, what this court referred to in Dogan as the primary duty and responsibility to establish conditions, as well as provide the means, which allow the applicants to return voluntarily, in safety and with dignity, to their homes and places of habitual residence, or to resettle voluntarily in another part of the country. A principle recognised in the UN Guiding Principles on Internal Displacement, in the UN's Pinheiro Principles of 2005, and in the case law of this court, and to be given effect save in cases of material impossibility, as a matter of obligation, not discretion. The second element is compensation for the loss of use of the applicant's homes and properties between 1990, when Turkey accepted the compulsory jurisdiction of the court, and the present day. This follows from the fact that the homes and properties throughout that period have remained in the applicant's ownership, but outside their control. There are principles well established by the court for calculating this compensation. The third element, which underlies everything else, is a law which not only makes these things possible, but does so in a way that complies with the various requirements that we've set out in paragraphs 41 and 45 to 46 of our memorial: legal certainty, clarity, accessibility, transparency. Does the conduct of Turkey, in particular as evidenced by the 2005 law and the operation of the IPC, remedy that systemic defect? In our submission, it does not even come close. I start with restitution. Turkey acknowledges at paragraph 48 of its memorial the legal principle that restitution must be granted when it is possible to do so. So far, so good. But Turkey then advances a number of reasons why, supposedly, it is not possible. That it would disturb the immovable property regime that has developed in northern Cyprus. That it would disturb the rights of current users of those properties. And that it may lead to public disorder. None of those arguments meets the stringent test for material impossibility that, for example, the International Law Commission set out in its draft articles on state responsibility. So, a regime governing immovable property purports to have been constructed in northern Cyprus. But as this court has been saying for many years, it is an unlawful one. It violates the Convention, as well as the legal order of the Republic of Cyprus. Its preservation cannot be a valid justification for refusing restitution. What about the current users of the properties? Well, as long ago as its merits judgment in Loizidou, this court said that the denial of the owner's rights could not be justified by the need to rehouse displaced Turkish Cypriots from the south of the island. Certainly regard should be given to them in the sense that they should be relocated in a humane fashion. But unlike the applicants in Kinchova against the Czech Republic, the case relied upon by Turkey, they have no rights under Article 1 of the First Protocol over Greek properties. And on Article 8, to paraphrase Durini against Italy, admissibility decision of the 12th of January 1994, even supposing that relocating current users would interfere with their right to a home, such interference would be justified under Article 8.2 as being necessary for the protection of the rights of the owners. At paragraph 39 of its memorial, even Turkey accepts that public order may be a problem only where property is located in an area whose population suffered particularly from intercommunal strife. It is Turkey that allowed current users to occupy Greek Cypriot properties in the first place, and Turkey that has the power to relocate them. In those circumstances, there can be no material impossibility on this ground either, as it has been understood by the ILC and others. The inadequacy of all three arguments is illustrated by the deserted and fenced-up area of Famagusta known as Varosha. Varosha is a ghost town, empty of inhabitants. Greek Cypriots, including quite a number of these applicants, can see their homes and properties fenced off, but they can't enjoy them. UN Security Council Resolution 550 of 1984 called for the transfer of Varosha to UN administration. Turkey has failed to comply, despite the fact that there are neither Turkish Cypriot occupiers nor public order implications. Varosha demonstrates that Turkey's so-called justifications for refusing restitution are nothing more than a smokescreen. But if you look at the 2005 law, it gets even worse, because the law excludes even the possibility of restitution in a vast range of cases, not limited to the three justifications relied upon in Turkey's memorial. Section 8.2 of the law excludes immediate restitution in all cases where property has been transferred to third persons, thus giving automatic priority to the interests of Turkish Cypriot occupants over those of Greek Cypriot owners. Even where property remains in the hands of the authorities, restitution remains wholly discretionary and is excluded altogether where the authorities choose to rely upon subjective and undefined notions such as national security and public interest. The prospects for restitution under this law are minimal, and intentionally so. The former Deputy Prime Minister of the TRNC, Mr. Denktash, said that no more than 4% of Greek Cypriot properties could be returned under the 2005 law with immediate effect, a statement which Turkey has not sought to deny either in its memorial or this morning. And as he also said in the same extract at Appendix D to our memorial, he noted that the reasoning of the draft law is the exchange and compensation and not the return of property.